International Seminar of Businesses and Human Rights, organized by HOMA, the Center of Businesses and Human Rights from the Federal University of Juiz de Fora. I am Liana. I will be moderating this panel this afternoon. I'm also an associate researcher with HOMA. So before anything else, I want to thank you for the invitation to be part of the Scientific and Organizing Committee in this event. I am a teacher of Human Rights and Borders from the Federal University of Dourados, coordinator of the Observatory of Previous Consultation Protocols. We have our guest speakers with us. I'm going to start by introducing them. But I want to thank, first of all, Boya Paté's presence, Professor Julian Martinez, and Carlos Federico Mares. We are still waiting for Bel Juruna from Juruna Utiá, Volta Grande Xingu. Our afternoon session, we are going to have 15 minutes for each speaker for their talks. Then we'll open for debate and questions. So all of you who have registered and that are participating, please feel free to ask your questions. There is this tool, Q&A. There is a button in the bottom bar of your screen. You can ask your questions, and we can also open your mics if you wish to ask questions. So to start this panel on Convention 169 of the ILO, International Labor Organization, territorial rights, free and informed previous consent, I'm going to introduce the three speakers to make our organization easier. In fact, I will introduce the four of them in the expectation of Bel should join us. She is in indigenous land. She may be facing some difficulty to connect. Royal Kiri Sobrinho Paté from the Choclan people holds a South Atlantic Forest Intercultural Teaching degree from the Federal University of Santa Catarina. Currently, it's an educator. He works in the education department in the state of Paraná, has experience in the area of environmental sciences. He is a chief of Choclan Coglum people in the National Forest of São Francisco de Paula in Rio Grande do Sul, and holds a master in education from the Federal University of Rio Grande do Sul. He is a HOMA researcher, the Center of Human Rights and Businesses from the Federal University of Juiz de Fora. Welcome, Boya. Professor Julian Martinez is the director, professor, and researcher of the Department of Constitutional Law from the Universidade Externado de Colombia, PhD and master in International Economic Law from University of Barcelona, master in Public Law from Universidade Externado de Colombia, in association with the Universities of Bologna, Carlos III, and Salamanca, specialist in foreign trade from the National University, Universidad Autónoma Nacional de México, senior professor, member of the Roundtable of Civil Society for Transparency of Extractivist Industry. I will interrupt the introductions to remind you that we have the translation services for our panel. You have this tool. The interpretation button is in your bottom bar. Professor Julian will make a presentation in Spanish, and so for Professor Julian Martinez, you can also access translation into Portuguese. So welcome, Professor Julian. It's a pleasure to have you here with us. And he's associate researcher with HOMA. Also contributes to our Center of Businesses and Human Rights. Professor Carlos Henrique Mares, the third speaker of our panel. He has a doctorate in law from the Federal University of Paraná, is part of the master's and doctorate degree in PPGD, the graduate studies program from Pontifical Catholic University of Paraná, full professor in land law, social environmental law, a leader in research for the environment and traditional societies and hegemonic society, was a prosecutor in the state of Paraná, secretary of culture, president of the Cultural Foundation of Curitiba, general prosecutor of the state of Paraná, president of FUNAI, general prosecutor with INCRA National Institute of Colonization and Land Reform, member of the uh, Directive Committee of ILSA in Bogotá, member and partner of ISA, Social Environmental Institute, member of the working group Laws, Social Classes and Reconfiguration of Capital, Social Environmental Essays and Other Texts, was a political exiled refugee in Uruguay, Chile, Denmark, and São Tomé and Príncipe in Africa. During the military dictatorship in the 1970s, have advocated for indigenous people since the 1980s. Beljuruna, that we hope can join us. She is a leadership in the people Juruna in Volta Grande do Chucro. She's a nurse, the advocate for human rights and of the territory, the life of the Xingu River, defensor, an advocate of the culture of the Junda people, the guardians of the Xingu River, researcher and collaborator of the protocols of communitary protocols for free informed consent. So we'll start our afternoon. Good afternoon to all of you who are here with us. I will start by passing the floor to Voye. Please, Voye, you have the floor. Good afternoon to all of you. It's a pleasure to be here with you to speak about this topic of the rights of indigenous peoples and of Convention 169 of ILO, and also of the violations that we are seeing here in Brazil against indigenous peoples. For us, the guarantee that we have for indigenous peoples for their rights and territories, we are contemplated by Convention 169 that offers protection guarantees to our territories and our rights. We are here to pursue these rights that have already been provided for in the Federal Constitution of Brazil. Brazil is a signatory of this international convention, and through that, we try to establish our rights as the originary people in this country. Oftentimes, these rights are violated, and the federal constitution of this country provides the right to our original territories. In these countries, we are seen as invaders of these lands. Some of us in our delimited indigenous lands, we are seen by people as invaders, invaders of lands that should belong to someone else, instead of seeing that these are millennial rights. For us, it's the opposite. Other people invaded our lands. Brazil, they consider that they discovered the country in the 1500s, but we had different peoples, different languages, different cultures before anything else. As the Choclen people, we were massacred in the last century, in the 19th century, But also in the 20th century, we were persecuted and almost eliminated. We were the last people to be contacted. When the Yunkan people in 1998 established contact, Choclen people in 1914 established the first contact with non-indigenous peoples. There were many other cases of massacres in the south region of the south of the country, also almost extermination of all indigenous peoples. So to make sure that we could survive, we had to migrate to other people. Well, we had a determination of indigenous land. We have Choclen in the Caigan land. And now the Choclen lives in this delimited Caigan land. This means that the Rio Grande do Sul has always been the Choclen territory. Most of the Choclen people lives in the Virana Macamor, a land in Santa Catarina. Today, in the Supreme Court, we have a case to return possession of these lands. These lands are in the state of Santa Catarina, and this trial is to be judged by Supreme Court. And if the Supreme Court recognizes our right to this territory as the original people, we'll be really happy. But sad, on the other hand, because we have already lost most of our territory. The Brazilian state must recognize our indigenous lands meant for our traditional uses and habits. In the Brazilian territory, indigenous rights are not recognized. We are in this fight, in the struggle in Rio Grande do Sul, where we had the possession of land returned to us on the last December 24th. Since 1994, we had been in the struggle. FUNAI, together with the federal government, was trying to establish the possession of the national forest, Flona. And as Choclen, we saw this violation from the beginning. We tried to establish a dialogue through FUNAI with the federal government, and we were not able to achieve this understanding by the national courts. In FUNAI in 2015, started a field research in order to recognize the Choclen territory in São Francisco de Paulo, and it was granted to us. It's a millennial ancestral territory, traditionally belonging to us. But even so, this possession was never granted to us. In December 12, 2020, we occupied the space in São Francisco de Paula because these violations of rights and the guarantees of previous informed consent was never conveyed to us. This genocidal government, with their policies and campaigns against us, after the election, they have put into practice what they claim during the campaign, that they wouldn't do away with all the delimited indigenous lands. The Ministry of the Environment have also put into practice many setbacks, many violations of indigenous peoples. Flona, Floresta Nacional, since they started working against us. Even FUNAI today calls us invaders of indigenous lands. The federal constitution provides our ancestral and military rights. The indigenous people's rights are being violated in all the national territory, in all the Brazilian territory. Basic right to health of the Yanomami people. Today, FUNAI forbid Fiocruz to enter the Yanomami territory to provide for their health needs. This sort of violation is happening in all the Brazilian territory. Today, FUNAI is against the indigenous peoples. Certainly, this is a step back for the Brazilian evolution, for the Brazilian progress. This agency connected to the Ministry of Justice, they are meant to defend the indigenous peoples. It's to defend our interests. It was created for the indigenous peoples and not to defend the mining workers or the agribusiness and defend the individual interests of other peoples. They were meant to protect our rights. And these violations, they have not started now, but since Brazil was first discovered, as they say, we had more than 300 different indigenous peoples in Brazil with their own languages, their own beliefs, they cultivated their memories, their traditional culture. And today I see that this administration that is ruling the country, in addition to violating our rights, they are liars. They have not attended the COP26 that happened recently, where the indigenous peoples presented their claims and presented our case so that the world could see the violations against indigenous lands, that indigenous lands are not being delimited. The president of FUNAI has been denying this to us. And just like us in São Francisco de Paula, in other indigenous lands that have been recovered, our people have been calling invaders. And this is a cause that is currently, it has been sent to our Supreme Court. This is the violation of our people. We know that the Brazilian territory and the federal constitution give us the right to ask for the delimitation as indigenous lands, and a simple expert opinion from the federal Attorney General office is enough. It seems to be stronger and than our rights that were, and this was a ruling by on October 5th, 1981. So this goes against our rights.
Artigos de 88, esquecendo não, se fazendo de loucos.
They forget, quote unquote, they pretend to forget that before 1988, we had been here for millennia. We, the Xoclen, were nearly exterminated from and expelled from the state of Rio Grande do Sul. So many peoples were displaced. So the Kaiowá, for example, most of them are reoccupied, and we are trying to retake our historical ancestral lands. Most of my people live in Santa Catarina state, but we originate from a different state, a neighboring state, where we're trying to retake our lands. So this whole story has been camouflaged, has been covered up. But in the current government, there has emerged something that had been lying low, which was the hate. The military dictatorship ended the mentality of the military dictatorship. The 64 to 85 military dictatorship has formally ended, but it has a legacy. So this hate that we see today comes from the against, and it's not just against indigenous people, the poor in general, LGBTs. We witness that hate currently in this country. And the wealth is going to a small number of people. The president saw the pandemic as an opportunity to profit, and they bought mansions during the pandemic, his family members. So leaders that went to COP26, when they got back to Brazil, their homes were invaded. Here in Rio Grande do Sul, the hate is patent against indigenous people. It had been slightly covered up or muffled, let's say, but now under the current government, it's explicit. One village near us here, near where I lived, was the prayer room was burned down, for example. So this injustice we're witnessing against our peoples, they have no respect for their neighbors even. So we need Brazilians and the international community to respect the rights of indigenous people, that the government should recognize its own laws that ensure the rights of indigenous people. There must be an outlook that is different in relation to indigenous people. There is a certain movement for Convention 169 for Brazil to withdraw from Convention 169, which we feel would be detrimental. So Convention 169 by itself does help us, even though the rights there are also in our constitution. And also the gold mining in our indigenous lands is bringing great harm. Our Yanomami people in northern Brazil are becoming contaminated with mercury, also the fish. So we need support because our rights are technically, they are in the law, but they need to be implemented. They need to be enforced. That's it from me. We are available, of course, to answer your questions. These are things, there are many more things that I might share with you here today, but the absurdities that are taking place are too many to fit into a 15-minute talk. So indigenous peoples are being massacred, being decimated, and the leaders that raise their voices to denounce all of this very often are victimized by the landowners, by state bodies, the justice system, even the FUNAI, which is the agency that should be protecting indigenous people. So if the justice system, instead of supporting our rights, is doing the opposite, is arresting us, where are we going from here? Where are we coming to? Our leaders are being killed and left at the roadside for them to be able to claim that it was a road accident. It's always the leaders that suffer this fate. So when the justice system goes inside our lands to arrest our leaders, so where can we run away from? If the justice system is against us, then justice is not being made, because the balance of justice only weighs and is only valid for the wealthy and has influence in this country, which is governed by money, by the capitalist system. So we have no influence. We don't even have lands to plant and feed ourselves. So we need recognition of our rights, of our lands, to survive. Thank you. Thank you, Voya, for your presentation. We know it was brief but very consistent, talking about the violations of rights, even of our Constitution and Convention 169. The Xokling people has been facing an enormous anguish with regard to the trial that is at the Supreme Federal Court, which is a case that has a general repercussion that would affect all the indigenous peoples in Brazil. So we hope, of course, that you can be successful, in that suit. Thank you very much for your struggle. I have the honor to share with you that I've met Voya in person in Brasilia recently in the mobilization because of this trial at the Supreme Court, which is called the temporal framework, which says that you can only demarcate indigenous land physically occupied by indigenous people prior to 1988. So now we have Bel Juruna, welcome. We have Professor Julian Martinez and Carlos Federico Mares from the Catholic University of Paraná. So Bel, I'm going to introduce you once again. I had already introduced all the panel members. So Bel is a leader of the Yujá Juruna people in the Juruna River area. She's a nurse from the Muratu village in the Volta Grande do Xingu. Studied in Altamira, in Pará, works with indigenous health, human rights advocate, defender of the territory of life and of the Xingu River, defender of the Yujá people's culture, people that self-identifies as guardians of the Xingu River, researcher and member of the Council of the Community Council for Free, Prior and Informed Consent of Indigenous Peoples. So you have 15 minutes. Feel free to go over if you need to, because your words are very important to us. Should I begin? I've already introduced you as a defender of the people, the river, the land, and life of the Yujá people, guardians of the river. You can begin, Bel, whenever you're ready. So Let's go. I'm Beljuruna. I'm from the Murutu village. My people is the Yujá Juruna people. We identify as the guardians of the river. So our struggle is totally focused on the river. We have this very strong bond with the Xingu River. And there is this big curve we call the Volta Grande in the river. So we have this self-affirmation, this self-identification. Our rights have been historically trampled on. Our river was dammed by the Belo Monte. So there was a detour, and this has been affecting our people. With these situations, this disregard, there are a lot of dogs around here. So even with the issues in regarding the Belo Monte Dam, and there was an area that was completely dried up because of the diversion of the waters to the dam. So we indigenous peoples have various struggles, but with a single objective, is for the laws that ensure our rights to be enforced and respected and then complied with, and that we should be heard about development projects. So we sought we are the only people in the medium Xingu area with a protocol of consultation fully done. It wasn't easy. It isn't easy. So our consultation protocol has been concluded, but things remain tough. And even are intensifying. It was because of Convention 169, with access to information, that we formulated our protocol based on the convention. The convention doesn't specify anything. It just affirms a right to all the peoples, indigenous people, Quilombola population. But it's through the protocol that we managed to detail, to specify how Juruna people as a people wants to be consulted. Through a protocol, we reached a consensus, the decision on how the Juruna people wants to be consulted, how we want to be served by Convention 169. We have different peoples have different customs. So in our protocol, we are able to show our differences for everyone. So in 2017, we did our best to conclude our protocol. There were many meetings, there were many problems. In 2017, there was a trial. There was a lawsuit about a Canadian mining company. So we did the protocol to get ready for when there was for the license to be given. So the prior license, what we call the prior license in Brazil, had already been granted with no consultation. So we went to Brasilia and we were able to stop and get a judge to stop the license of what we call installation, to actually set up the mine. So there's a study of environmental impact that is going on with a prior license already issued. We had no information whatsoever. So there were many business ventures happening in the region, and we were getting no information of what was happening around. And this is our territory. So with the support of Social Environmental Institute, ISA, we started to get organized because we have some knowledge of our territory. But regarding laws and these questions, we still are crawling, and we're having difficulty to understand these laws, and so we do need help. So ISA, the Social Environmental Institute, ISA, has been helping us a lot in this region, in this question. And so our government, we have laws here in the whole process of the dam and also the gold mining. We were never consulted about anything. It's a complicated situation for us. There were many meetings, public hearings. It was no use. The hearings were did not yield anything for us. So the public prosecution service did try to act, but we found it very difficult to ensure our rights. We don't manage to be heard, but our protocol has given us more autonomy. So we managed to get the suspension of the license to set up the mine. So we managed to get them to make an environmental impact study, because it's impossible to imagine yet another major project in a vulnerable situation, because all our water was detoured. The fish keep dying, the fish are sick. So our region, the fish aren't able to feed themselves properly because the fruits they eat are falling on dry land, not into the river. So the fish aren't reproducing. Because the streams where they used to spawn also have dried up. And even so, a foreign company is coming here to take wealth away from our people, our region. It's an absurd situation when we think about the laws and the rights and the current situation. I know there are even worse situations than ours. So, for example, nobody has been murdered. There are many threats, but none of them have been made concrete. So we haven't lost any leadership figures here. Thank God for that. But people have died in our region related to the projects from other movements and peoples. So we're doing our best to fight this, to adapt to the new reality. So we have our consultation protocol. The license was suspended. We managed to make the government understand that we needed to be consulted and to understand that we needed an environmental impact study. So we are still in struggle. Our protocol is not serving us only, but we not only for the mining problem. It helps us internally as well.
In terms of decisions that other people will take and that will affect our communities, what we want to have is like a greater organization so that we can be part of this decision making and not that someone else will make decisions that will affect our lives and the lives of our territories. We have this issue of the delimitation between among different peoples. We have 11 different peoples. In the beginning of the Belo Monte process, these were 19 tribes. Today we have 112 tribes. This strategy to divide, to weaken, is something that is happening there. Belo Monte, that's what they do. They use strategies in order to cause damage. They divide to conquer. Our protocol, so it helps us to create our own organization in our indigenous territory. We sometimes are able to unite our own people to understand what decisions are good for us, not only the leaders, but also the elderly, the children, the workers, the students. So our decision-making process is a broader one so that we have a self-determination in our own land. I don't know how much time I have. It's okay, Bel, you can go on, but we can conclude. So within this process of understanding and in our meetings, it's our form to create an organization and also to exchange knowledge about the process. It's very important for us to understand the problems that will affect us. But in our region, this consultation protocols are being very positive for us. So that's it. If you have any questions that I can help you with, because there's a number of different situations here that unfortunately we don't have time to address each one of them. Thank you, Bel. Yes, that's exactly how it is. For those who have questions to our speakers, Roy and Bel, Let's ask our questions in the Q&A session in the bottom bar here. Bel, thank you very much. It's very important for us to hear from you. You are a source of resistance. You represent the resistance of many peoples, not only Juruna and Jada Volta Grande, but other indigenous peoples that have been damaged, repairing communities, Amazon peoples that see you as a reference to their struggle. Other peoples who were victim of this major crime that was Belo Monte in your territory. Also through Professor Marés' group, I visited Altamira in a project together with SBPC, a public hearing on the rights of riparian communities, of riverside communities. In the cases of Belo Monte threats. And now the threat in Belo Monte territory, Bielusan, the open golden mines, the Canadian mining project. About Bielusan, I want to make a comment. Another point about our protocol. Through our protocol, we also acquired an understanding. I am a nursing technician in my tribe. We had 14 cases of COVID in 2020. Now we have 4 cases now in 2021, even if we were vaccinated. So through our protocol, we were able to establish an organization in our land. As we are not very close to Itamira, we are surrounded by farms. We are close to the city of Altamira. So we had problems with the people traveling inside our communities and crossing our land. But we reached a consensus. We were able to organize ourselves and close our tribe.
Pequenas, mas que fazem a diferença na vida das pessoas, né? E, enfim, a maior seguridade da saúde de cada um, né? Tanto os mais velhos como as crianças e os adolescentes. E a outra situação é que nós, povos indígenas, jurunas, daqui e Paquistão, a gente tem um protocolo de consulta. A gente conseguiu, né, fazer com que o governo reconhecesse, né, o nosso direito dentro da Convenção 69 e a gente, com o nosso protocolo, a gente conseguiu mostrar para eles que nós temos os passos, passo a passo, né, de como o povo juruna quer ser consultado dentro da Convenção 69. Né? O povo juruna está tendo esse privilégio, mas o que acontece aqui é que tem outros povos que não têm protocolo de consulta, como o povo arara, que fica na região a ser explorada, né, pela mineradora do Canadá. E existem outros povos indígenas fora da TI também, né, porque o protocolo ele é da TI Paxamba, né, e não, né, de todo o povo juruna que mora na Volta Grande. E eu percebi, diante de um seminário recente que a gente teve, que os direitos das pessoas são violados, enfim, não são respeitados, né? Somente porque eles não têm protocolo, como se não existisse a Convenção 69. O Canadá ele não está respeitando território nem a vida das pessoas aqui em torno, né? Parece que a gente está sendo privilegiado por ter um protocolo de consulta, ou parece que as pessoas ribeirinhos, né, indígenas que não
indigenous people that don't live inside of indigenous lands The Arara people live in villages outside of indigenous land. It's as if they didn't matter. It's as if they didn't matter for this Canadian mining company. And so we are indignant about that because there is a right of Convention 169. People need to be consulted. They want to hear only the Juruna people because we have a consultation protocol. Somebody questioned this. They created intrigues. People said, we are bigger than them? No, I said no, we're bigger than no one. We don't understand why Canada, the Canadian company is not consulting the other peoples. We don't like the fact that we are the only ones being consulted. So we have the current setting of the, it makes us very angry about how things happen. We have a protocol, we have a guideline, but Convention 169 is not just for those that have a protocol written down. It's for all the peoples that have the right to be consulted in the face of any venture, anything that can affect their lives, their ways of life. All the peoples have the right to be consulted by anything that can enter their territory and affect their homes. The place where the mining company wants to establish itself, it affects all of us. We all depend on our river, on our land. We happen to have our land demarcated, but we use the same space to survive as many other peoples. So all of them have the right to be consulted. It's not just because we got organized and have put together a protocol that we are the only ones that are going to be listened to. These information for the riverine populations that are not indigenous but depend on artisanal fishing, they are often unable to access this information that we have managed to access as indigenous people. And that makes me think we indigenous people, our struggle, we face different situations, but we all want the same thing, which is to defend the forest, defend the territory. We want not just our lands to be demarcated, we want the forest to remain standing. That is our whole struggle, because we want to survive, to preserve our forests, preserve our rivers. That's it. The whole struggle is about that. That's the objective of preserving our territory. And the riverine communities have a very similar way of life to us, very similar to the indigenous peoples, but they face the similar situation. The Canadian corporation is not respecting the other populations. There are many other areas that they are looking to prospecting to exploit gold, to mine for gold. So we were able to suspend the license to operate, but our rights are only being respected to a certain small extent. But there are many other people that are being disrespected. So anything that gets done to them will affect us as well. Because that's the question that is the key question. Is the respect for all the peoples who we don't want to be the only ones to be consulted. And Convention 169 is very clear because the protocol is only the detailing of how a particular people wishes to be consulted, but all peoples have to be consulted regardless of having a protocol. So we can be reached. We have our own, this is for us, it's practically a law, and it all derives from Convention 169. So that's the points I wanted to share with you. And we want this mining company to consider all the peoples in the region. I can't say that they are respecting Convention 169 because it is just following the protocol of a single people. So they're not respecting the convention as a whole. So they're violating rights of the whole population in the region. That's it from me.
Thank you, Bel. We have a question from Ana Luisa, piggybacking on something that Bel said. The public hearing that I mentioned was in 2016. So Belo Monte had already been built. It was a hearing called by the federal public ministry to discuss the violations that had already been perpetrated. So to discuss territorial rights, if these communities could return to their territories, to protect the riverside lifestyle. Another object of our morning panel, the forced migrations, how these communities were removed from their territories, for their long life territories, and reallocated to Uzhuki. I think that Bel can also explain the urban resettlements that destroy the traditional lifestyle, and they go to Altamira. For the entrepreneurs, their vision it is as if they were removing communities from poverty, because instead of living in a tribe, they now live in brick and mortar homes. So this is another kind of prejudice against the traditional lifestyle and culture. So Ana Luisa asked if there was really consultation, if the river populations were consulted, in fact, before Belo Monte. So this process of Belo Monte, there was no consultation. There were meetings, several meetings. I think we did not understand, in fact, what it was about to happen. I think it was in the year 2000, 2002. So at that time, we were living in our territory regularly without even thinking what could happen. So these meetings were intensified. We started to have more information about the dam. And it was like meetings in meetings. Our lifestyle started to change. There was several public hearings that we attended. We also challenged several points. Until today, we are always trying to express our point of view on how. And here we have to monitor. We have to have access to what happens to our meeting in the Belo Monte Dam. They claim that they monitor our territory, but we don't have any participation. with what happens to our people, and information don't get to us. So we need like real monitoring, and we want to know how we are going to live without water in the future of our region. In this whole process, there were meetings, exchange of information. We challenged their propositions. We asked questions. We described how was our lifestyle, the way in which we lived. And then there was an agreement to for the approve the license to operate. So all of our struggle led to nothing. They traded our life, our water, and all the indigenous peoples in the mid-Xingu. We received like small territories for each one of our peoples. And so there was no free informed consent, previous consent. This process of consultation is a very detailed process. So we were not previously consulted. We were not even heard. Everything that we said, all of our questions, all of our struggle, they did not hear anything. Nothing was taken into consideration. All the time that we dedicated to them, it was not respected. We were not respected. About the homes that we lived in, the riverside houses where we lived, we were reallocated to this outskirts of Itamira. These were neighborhoods that the electricity utility built and to reallocate families. And there were people who liked to live in brick and mortar homes, but there were other people that were directly affected in their lifestyle because they were removed from the riverside and sent to the most distant regions of the city in the Altamira territory. So for the people who had like a riverside lifestyle that took it to live from their boats, who had to take care of their boats, they had their rights removed to continue with this traditional lifestyle. And there are many of these families who are living in extreme poverty in these households, because it's not the house that gives you your everyday food. What gives you your food is the boats that are side by side with those riverside homes. So those boats is what give these people their livelihood. So these families, they think of returning. I say that because my father is 70 years old. My mother is 56, but she continues with a traditional lifestyle. Every month, my father goes to the bank to get his retirement payment, and he goes by boat. He bought now a bigger boat. He lives here with great hardship to go to get his pay. He bought a bigger boat because after the river was transferred, he lives from the lake formed by the dam, and there were many boats that have already sunk. It's a hard place to navigate, so he needed a bigger boat to facilitate, so he would not run as many risks in this Belo Monte Lake. My father, he pays 25 reals a day for a person to take care of his mom in the period when he is in Altamira. He spends there 5 days, he will pay 25 reals per day. For people that don't have anything, this is too much. And these people that live in these neighborhoods that where they were transferred, they cannot pay for people to look after their boats in the river. Their livelihood is very difficult. So how can they pay 25 reais a day? Because sometimes people live hundreds of kilometers away from the riverside. Their lifestyle was completely disrupted. They, although they live traditionally in very humble homes, they have food to eat every day. And today I know people that they complain a lot. Sometimes they come to spend days here to fish in order to survive, because otherwise they cannot live. So that's it. Thank you, Belle. So we also anticipated the Q&A session to make the best of Belle Julian's present. In spite of all connection difficulties, so that we can know more of her work in the tribes' health facilities as a nurse technician. So now I invite Professor Julian Martinez, who is director and professor in the Department of Constitutional Law from Universidad Externada de Colombia, to start his talk. So welcome, Professor, and please, you have the floor. Diana, thank you. So I take the opportunity to congratulate Homa and the team, and also my colleagues, other members of the panel. I want to share with you my slides to make the understanding easier. And especially after hearing what Belle just told us, I try to rethink this question of Convention 169 and this issue of previous free informed consent. Of course, that we must take into account what we had in the 1950s with Convention 107. So we had convention after a lot of work and a lot of developments, we reached Convention 169. So seeing the experience of Latin American people, it's necessary to be critical and to magnify the vision that pay more attention to this issue, because there are new risks. And that's what it's all about. So if you allow me, first I'm going to speak about the problems. The question of origin is the most important here. I'm sorry, I have to change my translation mode here because it's interrupting me.
Segundo. Aquí, perdón. Ahora. Esto. Ahora sí. Ahora sí, discúlpeme. Entonces, les decía que sin ánimo de desconocer
So 169, Convention 169 is important for Latin American countries, but it's important to rethink because we have some challenges. One is the challenge of origin. The other one is the development of the convention. So I titled my intervention called Indigenizing Prior Consultation. So this is a research of my group, the Observatory, Martin Posadas and Alancheros. I think the most complex thing to understand is what is the grounding of the convention. There are problems that are structural, that are deep-seated in the construction of Convention 169. So the first problem, the first challenge is that development is a manifestation of biopower. What does this mean? Since the Second World War, from the speech of President Truman, development became a tool to foment economic growth and scientific knowledge in the world. But I ask myself, what is being developed? So not all the states and not all the peoples receive the fruits of this economic growth and enhancement of scientific knowledge, because this tool defines who lives and who dies. So it creates hierarchies between races, defining some of them as inferior in the face of others, others that are better and or worse. So it's an expression of power. So it's about the establishment of a biological domination through development to define who should live and who should die. Using the words of Michel Foucault, so development is converted into a biopower that is not limited to human life, but also impacts the environment, because in the search of this promised land of prosperity, there's a superimposition of corporations and their economic interests over the territory of indigenous peoples and nature. So this developmentalist mentality brings about problems. For example, what Bell was mentioning, the lack of knowledge, the disregard of what it means for each community, the land, the tree, the river, the mountain. So development converts the subsoil into a source of minerals, the river into a source of energy, and so the forests into arable land for agriculture or ranching. So development objectifies the spirit of our peoples, transforming them into factors of production. So this is the first problem, the grounding. Let's try to explain the second problem, which is how development determines the construction, the spirit of the Convention 169. It has virtues because it changed the model of integrationism, where indigenous peoples were seen as savages and their territories as empty spaces. So there were advances, but Convention 169, by having three main actors, companies, state, and workers, leaves outside those that are the subject, in other words, the indigenous peoples. So what are the effects of having development as one of the groundings, one of the fundamentals of Convention 169? In the pro-development, developmentalist concept, it's clear that in the negotiations of Convention 169 of ILO is the founding of the current model, which is a prior consultation. The indigenous people wanted an instrument of control that would favor their possibility of consenting and exercise as much as possible their rights of self-determination, and to have control over their territories, their ancestral territories. So the convention ended up yielding to the states and the corporations, which is to say that the consultation became converted into a tool which is only participatory. There was no adoption of the vocabulary we want. Simply, it's an international tool that gives over the use, the management, but leaves out the word, leaves out the last word to the states and the judiciaries. So I diagnose the problem, and I want to tell you a little bit about how can we indigenize, in other words, how to rethink consultations through the cosmovision of indigenous peoples, how to indigenize consultation process. In my view, the first step to achieve this change is to start off from the consent of the control of the territory as a material element that is inherent to the rights of all the communities. If you look at how the convention alludes to the territory as a space of preservation, cultural, language, of knowledge, but the substance, material substance of the self-determination identity of the peoples. So I understand that starting off not from the consultation, but generating an instrument of participation where there is this processes of asking community what do they think, but in the ultimately the decision is up to the government. That breaks with this idea or generates a destructuring of the material expression of the rights of indigenous peoples. The second contribution to indigenize the prior consultation is the construction of a dialogue through this theory, which is called controlled mistake. So processes of participation in modern democratic states must be not only about dialogue. So in spaces where you exchange ideas and where processes of information are exchanged, of decision making, it has to go much further. The processes of dialogue have to be deliberative. In other words, they have to close the gaps between these subjects who are in a position of need and defenseless. And then, so how can you understand that we find ourselves in the framework of a different kind of dialogue? In other words, this controlled mistakes allows us to understand certain practices of the indigenous peoples by recognizing when two people are talking about the same thing, trees, rivers, soils, without noticing that are imagined in a different way. So this practice wants to undo this shocks between the cosmovision of Western culture of a capitalist society and recognize the differences by understanding that it's not just about two forms of understanding the world. I'm talking about a capitalist neoliberal ideology in the face of different cosmovisions. So they are different worlds that are looking at each other. So my last proposal, and with that I close, is to recognize the importance of the knowledge, the perspectives, and the needs of each indigenous people. So perhaps one of the lessons, the most important lessons that the experience that I acquired with indigenous peoples in different parts of Colombia is that there isn't one single cosmovision. Each people feels its knowledge, its rights differently, conceives of them differently. So prior consultation cannot be a standard magical formula that universalizes needs and the ways of looking at the world by each of the indigenous peoples. So that said, I want to arrive at my conclusion. So if prior consultation is one of the most significant achievements under the logic of the Western legal world, we cannot disregard that it has deep-seated weaknesses that we must improve. We have a historic debt, and this debt invites us to rethink and build the basic elements that make up this figure, as well as the way it's being implemented. So we know that the Constitutional Court in Colombia is an example. So there is this thing called the post-consultation, which is a change. So it has to be prior, and it has to be free, and it has to be informed, and there has to be good faith. So in our courts, some of the more progressive courts, then there are not many of them. There's no guarantee that things are being well done. So judicial activism wants to change history and generate a demand of what in our constitution, as in others like in Ecuador or Bolivia, where they talk about a society and a pluri-ethnic society. There's a long path to go along, because whenever there's a collision between the interests of corporations, economic interests, and the interests of the indigenous peoples and of nature, there's always a loser, and that doesn't seem to change. So I just want to say that to achieve a truthful guarantee of rights of indigenous peoples, it's not enough to have these crumbs, which ultimately it's a process to socialize, because very little can be decided by people in the face of a major corporation and the state. So without further ado, then I thank you all. I thank the ALMA colleagues, especially for having welcomed me into their midst as an associate researcher. Thank you very much. Thank you, Professor Julian. Professor Julian brings us very important points that I'm here anxious for the debate. I'm going to ask people to write the questions in the Q&A. or wait until the end to ask them orally. Above this reference we have from Colombia in terms of the use of prior consent and the advances of the constitutional courts, even though we do know, even though there are advances, we know that it's not a rosy world. There are many challenges that remain, particularly in terms of prior consultation not just being procedural, just to make the projects feasible, the licensing, etc. So Professor Julian brings its very important points to think about the autonomy of the peoples, the freedom of self-determination, the control over their territories, the free, prior, and informed consent, and not just consultation as a tool just to make the development project viable. So when we think about consent, we also must think about non-consent, the idea that the peoples have the right to preserve their spiritual, cultural, physical integrity. So now I hand over to Professor Carlos Federico Marés for his presentation. I'm sure it will enrich us even further for the debate going forward. Good afternoon. Thank you very much, Liana. It's great to be here with you debating this very important question. In this seminar, such an important one that is being developed here. I want to say a very special thank you to Oma, a special greeting to Bel and Vaya, who've already presented the question most concretely about relations between indigenous peoples and the national states, and also Dr. Julian Tolle, who said magnificent words about what is and what is the reach of Convention 169. So I think it's very important, starting off from these three presentations that came before me. So the dispute that exists in Latin America, not just in Brazil, all over Latin America, and extended also to other continents, an important alliance with Africa, also relating to Asia and Europe. There's this process of globalization that is conducted by the capitalist system. It raised the dispute about the future, let's say, to an international class struggle. This discussion of Convention 169 of indigenous rights here in Latin America, it's embedded in that process of class struggle. So it's an internal debate within capitalism. It became, but it didn't used to be. In Latin America, very specifically, all the discussion. So Fausto Reinaga from Bolivia used to discuss an external. It's not possible to discuss internally within capitalism. The indigenous peoples should not discuss within capitalism. So they should conduct an indigenous revolution. So there was around the middle of the 20th century, there was a change in the perspective, not of the indigenous peoples, but of the concrete action regarding their action within the capitalist system. So Dr. Julian shows us very clearly that the construction of Convention 169 is inserted in this formation of the modern identity of the capitalist system. And what do the indigenous peoples do in the 20th century? So after in the second half of the 20th century, the indigenous peoples decide to alter their legal structures of the national states and international norms to be able to include, to break the hegemony, to have collective rights and break the hegemony of individual rights. And they were very competent about this. And many constitutions, to the point where the legal world started to build a new theory, a constitutional theory. And this new theory, which was called new, but in fact, it has a new ingredient, which is an anti-colonial ingredient. So what is missing in this theory of the new constitutionalism, the recognition of this anti-colonial condition. And so this anti-colonial condition is also present in Convention 169 as an achievement, as a victory of the indigenous movements, but not only, also of other traditional peoples. Of course, the indigenous vanguard is clear in the process. And the non-indigenous movements take on these advances, these demands later, although they were there, but publicly and organically, they take them on after the indigenous peoples, after the change in the legal systems. But the change in the legal system in the modern world, we have to look at that very critically, because it's not always the changes in the legal systems matter and get translated into changes in social practice, because national states and major capital still, even if they yield different legal rules, they don't apply them.
They do not apply them because they are the ones who have the hegemony and this enforceability of laws. And this is a problem that is well known exactly in this process of class struggle. And that's why I use this phrase. There is a category of social sciences called class struggle. So what happened in this change? We could analyze the different conventions, Convention 169, but in this change, there was the introduction of a right proposed by indigenous peoples, the right of existence, of a collective existence. Therefore, the existence of a collective right was transferred as was transformed into a right, and this is the existence to a collective existence and the creation of the subject of this right, something that did not exist before in the modern system. And who is the subject of this collective right? It's each one of these peoples, and in the way in which they present themselves, because I could say that I know peoples in Brazil that cannot be called, they themselves are not called collectively as peoples. They are communities. They are smaller communities. I have a doctorate student that calls them parts of peoples, and they see themselves as a subject of this collective right. So one single people can have different subjects. This is a complexity of the modern law. The modern law, if looks at this strictly, people cannot understand, and the legalists, the experts, the legal experts cannot understand this concept of collective subjects of rights. But this is the first achievement. This is the first victory. Of course, that in order for these people to exist, and this is the most immediate consequence and even harder to understand, to exist, these people must be in a place, and this place is their territory. It's not a place of production is not, as Dr. Julian Tolli said, a place of development. It's a place to exist, and therefore it's a place that is integrated, appropriated for all of the processes of cosmovision. So it's not just any place, because in the existence of the people, you have the existence of everything that surrounds these people, which is nature, the animals, the plants, the rivers and the mountains, the spirits and the sacred. So to that, that is what the modern world calls territory, but it doesn't matter how you call it. You can call it space, environment, territory. Geography can call them whatever they want, but what they are, in fact, what it is, in fact, is the place where the people live and develops their own culture. This is really hard for the law to understand. So we have this two sides of law: the collective subject, their right to exist, and their right to be in a certain place. Therefore, the consent, the free from previous consent results from that. It's not a right in itself, but as the legal law is very strict, very square, within boxes that do not communicate with each other, they only communicate with each other when the solution is not exactly in one box. So the modern law is squared, is limited. They cannot know that before the consultation. First, you have to acknowledge the existence of the people, and the consultation, it results from that. So it should be done, it must be done, it will be done, but it will be done always from the two other rights. It's not a procedure in itself. The procedure, it's a result of that. It's the route of existing and being in a certain place. That's why those who have a say on these procedures are the peoples themselves. And that's why you have this idea that those who have a say on the procedure, and this is the name that was given to it, the previous free informed consentment, this is called consultation protocol. And then you can put adjectives to it. Autonomous protocols, popular protocols, community protocols, you can call them whatever you want. But what does it mean? In fact, it means that those who establish these procedures are the people. It's the people who establish them. And why is that? Because what is at stake is their right to exist and their right to be in a certain place. To imagine that a legal expert that knows the civil law and that have learned that the subject is an individual that learned from Hegel, to understand, to imagine that they will understand this collective subject is almost too much, but it is a requirement of our time. And who will make this legal experts understand? These are the peoples themselves. And very wisely, these people start to build not only the protocols, to write their own protocols, to show their own protocols, to present their own protocols. There are nothing more than the expression of their self-determination, and therefore the expression of their own thinking. So, and each one is different here. And by presenting this, in building this concept, they teach, or they intend to teach, or they will teach the legal experts of this very squared modern law that this box does not, cannot contain this concept. So they have to disrupt this old laws. Well, but this, in fact, these are new laws. These are much younger than indigenous laws. legal law, modern law, has like what, 200 or 300 years of attempts. So it's much more recent. They are much younger than the indigenous rights, who are based on the tradition that were created. We don't even know how long ago. So this new modern law must be mm, rethought, must be remodelated. And that's what indigenous people started to do in the middle of the 20th century. This means that ultimately that what we are trying to do and what we are trying to, you have the constitutions and you have the Convention 169. So what we have included in our standards are the standards that companies don't and states don't intend to comply with, and they don't intend to comply with the laws of the rights of animals, of family agricultures. They don't intend to abide by them. Why is not? Because it goes against their cosmo thinking, their cosmo culture, against the way they think things should be. So when they disrupt these paradigms, when they included this in Convention 169, it's the start of a new struggle to put this into practice. So what Voya and Bell present to us is the way in which this struggle continues. Bell referred to Choclain and the Choclain suit that is in the Supreme Court. It's a very hard decision for the Supreme Court, but easy for us. So I imagine that indigenous peoples look at it and they think, what's so hard about analyzing this? As Avoya said, we were already here for centuries. So how difficult is it to understand that? But it is difficult, it is hard. The decision to be made about this temporal landmark, even if the good decision is taken, that provides like effectiveness to our constitution, our struggle continues, because to put this decision into practice, governments and companies with their militants and their armies, their militias, they will not be willing to do it. And once again, they will try to disrupt with this right that is guaranteed by the convention, by the courts, and by the constitution. That's why this is a long-term struggle, with the advantage that now in the 20th century, it has gained a new dimension in Latin America, which is the dimension that points out to victory, which is an anti-colonial, anti-capitalist struggle. So therefore, all of these standards, the application of these standards, they will lead ultimately into a deep social disruption that disrupts the capitalism and colonialism. Thank you. Thank you, Professor Marez. It's very a pleasure to hear from you. Very deep challenges for us to reflect on the field of law and the relations of the modern state and colonialism and peoples. It's something that we are still unfortunately living so far, and we must rethink of the future of our societies and the coexistence of different peoples and traditional communities. Now we open for debate. I hope that Voya and Bel are still with us. Perfect, Voya. So good to have you here. So there are other questions. We are opening for questions now. So we have this opportunity here. I'm going to ask the first questions to encourage the others to participate. I also received a message from Felipe, a home researcher, that he is supporting us as a co-host here in this live, and he would like to ask some questions. So Felipe, I open to you, and we return. Good afternoon. First of all, I want to thank you for the wonderful talks. I want to thank Voya Bell, Professor Julian, Professor Mares. My question to Professor Mares, within these autonomous consultation protocols in Brazil, is there any procedure that was adopted by the judicial institutions that was considered as successful in terms of respect to the self-determination and organization of these peoples, or all of them suffer this difficulty, these hardships of this very squared modern law? This is my question, and I want to thank all the speakers, and more especially Voya and Bell. Thank you, Felipe. So now I pass to Professor Mares. I thought that we were going to answer to all the questions, but it's easier like this. I'm sorry, I forgot the details of Felipe's questions already, but Felipe, from the point of view of the juridical changes, we are still taking baby steps. This is just the beginning. The protocols, even if there is a lot of resistance from the traditional legalists, they already start to produce effects. There is they are already forewarned. They are already preparing to know that there will be changes. I think that these traditional legalists, they see this as a revolutionary. They think that these protocols are laws and standards whose source is the people themselves, but that they cannot go against established law. So they are an addition to the established law. I have seen interpretations such as this from the traditional legalists. Some that are a little bit more advanced, they say that this is the materialization of the juridical pluralism of a law that can collect plural ideas. And that's not it. This is different types of rights, these different types of formulations. Therefore, of different effects. Therefore, this interpretation is much easier to understand. And why do I say that this has good results? Because we have somehow avoided in some places decisions against the protocols. I have seen direct consequences that when there are protocols, the greed of companies and states are frustrated. They are frustrated because they will have to use different processes. There are positive examples. Are there positive examples? I wouldn't say that. There are incipient positive examples, initial positive examples, yes. And I want to highlight that one of the most important achievements of our original peoples in Brazil is the beginning of a change in the attitude of ICMBio in terms of national parks and protection areas that were understood as areas that excluded people. So this indigenous movement, and now not only belonging to indigenous peoples, but also of quilombola communities and other traditional peoples, they are making this interpretation of the year 2000, of a law of the year 2000, this interpretation as it should be. It's not a law that excludes people. This is about nature protection. And this protection is provided by people as well. People protect nature. And what are these people? Why is that? Because they live with nature in their own territory. So this idea of the right to exist and to be in this territory start to penetrate our judiciary. There is a recent expert opinion provided by ICMBio that says that it's a result of this general movement of the willingness of people to present their own realities. Thank you, Professor Marez. We have other questions.
Okay, there's no need to complement, but just to complement. So Felipe asked if there is any procedure for the formulation of the protocol. So I'm going to touch on this point, which is also critical, that for us non-indigenous people to understand that we are not the ones that can evaluate whether the protocols are successful or not in terms of the self-determination of the peoples. If they are built by the peoples themselves and that express their legal diversity, that express the form of organization of that people, of course, Bell can answer better. So I heard this from leadership of Atix from the Xingu region. He said that not everything is in the protocol. All the whole cosmovision of the people, the ancestral laws, their jurisdiction, how peoples organize themselves and deliberate collectively. The protocol is a tool for a dialogue with the society with a view to a consultation process. But the limitation is in our society. So some people, so this leader from Atix, on one occasion, in a meeting, a preparatory meeting to build the protocol of the Rio Negro peoples and this exercise of exchanges between peoples, this guy said there are things that we don't want to be in the protocol. And you won't understand, the state won't understand. There are questions that are really internal that we're not going to put on paper on this document, which shows this limitation, this issue of modernity. The peoples have this need to put on paper, to be able to have a decent consultation process. They're forced to put on paper things they don't want to. So this is a question I wanted to raise about Colombia. I remember, Professor, in the Sierra Nevada of Santa Marta visit, where the four peoples, leaders of these peoples were discussing, because of a decision of the Constitutional Court, building an autonomous protocol of the peoples, and the leader, Kogiumamo, also this criticism that the ancestral law could not be put on paper in this document. There was a tension between the various peoples of the Sierra Nevada. And then I came back to Brazil and I didn't follow up. But 2 years later, I saw that the Arhuaco people were publicized, but not the 4 peoples of the Sierra Nevada. And maybe these are questions that would be interesting to discuss with Bell. So territories that are shared between peoples, and the Juruna people built their protocol, but the other peoples have not yet mobilized, have not put this on paper to build their own protocol. This would be interesting. It doesn't mean that the state doesn't have its duty to consult. And the state cannot use this limited view. So today in Brazil, there are 60 protocols, autonomous protocols of Quilombola peoples, indigenous peoples, traveling communities. There are various collective subjects, as Professor Marez mentioned, relating to Convention 169. And the peoples that don't have the protocols, written protocols, doesn't mean that the state has the right or corporations to use that as an excuse. Oh, they have no protocol, so I'm not going to consult them. I think we have to invert the logic. The protocol is something beyond. It's a bonus. That the peoples demonstrate how they organize themselves, and they just are spelling out how the process of consultation can be respectful of their specificities, but it's not a homogeneous procedure for different realities and different territories. So just to add a little spice to the question, and also, Professor Julian, there is an agency connected to the Ministry of the Interior about prior consent, about prior consultation, because in Brazil, something that is very worrying, some decisions, legal decisions have been mistaken that transfer to the company the competency that belongs to the state, which is to conduct the prior consultation. So that is a incorrect interpretation of what judge that said that in the face of the absence of the state, as if the corporation would act in good faith in taking over that role. So I would like to hear from you on these points, because we cannot confuse the two things. What is obligation of the state, duty of the state? So we're talking about human rights and corporations here. We can also think about this conduct that sort of deconfigures, unsettles the whole process of consultation to the peoples, co-opting leaders, restricting and violating the principles of good faith. This is one of the points I wanted to raise to understand how in Colombia, how Professor Julian, so this directorate within the Ministry of the Interior, how have the experiences been in terms of the state leading the consultation processes? I'm gonna come back here. Sabrina, if you want to ask your question, you can open up your mic, or I can read it. Somebody has their hand up. Let me see. Alberto from Uruguay. Sabrina, if you want to speak, you may. Shall I read your question? She asks whether free, prior, informed consultation has been invoked in the right to say no to mining activities. This was the case of the Lago Grande agro-extractivist project in Pará. I'd like the panelists to talk about this in terms of the right to say no to confront the mining industry. So, okay, with those, I hand over to our panelists. Voya, Bell, I don't see Bell. Is Voya here? I would like to ask a question to Professor Marés if he has access to the ICMBio opinion. ICMBio has denied the rights of indigenous people, particularly to the Xoclen people, and denies access to the national forest. So we're actually suing. And of course, the free, prior, informed consent, as Liana said, the government, the Brazilian state, yields on its responsibilities and sends it to the private sector. So since 1998, we go to the prosecution service together with ICMBio to have recognition of our territory. And this government gave to another company before our consultation was answered. And the concession has been granted to the private. There have been public hearings without our presence, without our consent. So when we went to the justice system and the judge that heard us, he said, it's no longer in the ICMBio, it's up to the private sector to hold the hearing after the concession has already been made. So what happens to the rights of our people? This is a violation of our indigenous rights. So Xoclen here are here to fight for the return of their territory, and we were very much harmed by this concession to the private sector. We've been running. We don't have anywhere else to no more recourse. It went to the Supreme Court, and so it's up to the Supreme Court to decide. They said they haven't gone into the merit. So these violations of rights of the Xoclen people that are inscribed in the federal constitution and Convention 169. So I didn't know about this ICMBio opinion. If you have it, we want to have a look at it if it's open, if the access exists. I have it and I can send it to you. It's not just an opinion there. It's and the general council of the ICMBio agrees with the opinion, but the opinion refers to the areas of integral protection, which is not FLONA. FLONA is a national forest. They had a different regime, but I think it would be applicable. If an area of integral protection, like a park, according to the opinion, I've always thought the same. So the opinion agrees with me, can admit the presence of indigenous peoples and other traditional peoples. So in a national forest, even more so. There has to be even greater protection of indigenous or traditional populations. I can send you the opinion. I think Liana can be the bridge between us. Okay, I'll send it to you today.
Obrigada. Então, passo aqui para vocês também seguirem as considerações.
Não entendi, Eliana. É para a gente responder as questões?
Isso, professor. Tem a questão que a Sabrina nos colocou aqui também, sobre o direito de dizer não. Nesse ícone QIA, a gente consegue visualizar a pergunta da Sabrina.
Ah, eu posso olhar ali, é?
Isso.
QIA, tá.
Aqui eu estou respondendo pelo chat aqui também, até para que eu entendi a questão do Felipe, né? Eu até complementei aqui que no Brasil a gente, em relação à observância dos protocolos.
So regarding the observance of protocols, that's what Felipe was talking about. So we have more than 60 protocols in total. The peoples have used them as strategy of struggle and resistance, as the case of Beljuruna. I was writing here in the chat, there's the case that Beljuruna said, there's a legal decision that recognizes the protocol and that suspended the license for the mining company to set up. We don't have many examples to say that the state is complying, is observing protocols in the context of processes of consultation. The protocols exist to demonstrate and impose on the state the observance. But now I hand over to Professor. I think Professor Julian should jump in here. The question in the Q&A by Sabrina, it's a key question about the right to consultation, because when it was written, when Convention 169 was written, since when it was written, our interpretation was that the consultation was to get the consent. So you can consent or not consent, so there should be a right to say no. Even jurists who are not that square contested no. How can it be there be a veto power against development, against the state, the wishes of the corporations? Way back when, 20 years ago, more than 20 years ago. And there was an evolution in this regard, and I see with great joy that there was an evolution. There was a process of struggle that was very intense. They resisted. They have always wanted to say no, have expressed this wish, and they created this interpretation that really it's about consent. So if you say yes, you are allowed to say no. That has advanced. So it's more or less advanced. Those less square jurists who used to say that there was no right to veto are starting to say that yes, there is a right to veto, starting to recognize this, which is a good thing. Part of the jurists, I'm talking about Brazil now, only specifically Brazil. They're starting to say yes, it's about the right to say no. I think recent decisions by the International Court of Justice about this indicate that there will be a jurisprudence, a case law taking hold that there is a right to say no. And I will complement, if there's no right to say no, then there's no consultation, because it makes no sense. If the state and corporations have the obligation just to convince the peoples to do what they want, then that's not a right of consultation, because if peoples are saying no, it's because they are preserving their own culture. So to go against that is to destroy the culture. In other words, not to ensure the right to exist. So if we start off from the right to exist, then we have to conclude that there is a right to say no. I think there has been advances, but I also want to say the following, Sabrina. There is an advance within the system. The system has limits. There'll be a moment that the system has to be ruptured, let's say, because the right of the indigenous peoples have to say no to mining. I also want the right to say no to mining. So I want a system, a global system without mining, for example. But I can't yet because I'm subject to the laws of capitalism. So right now, so there has to be a moment of rupture with the capitalist system.
Is there any other question? Yes, Professor, go on. As I have to leave, I want to thank you, first of all, thank the organizers, and after hearing to Professor Marez, it's an honor, because he has such a great vision. His comments really into our reason of a great enthusiasm, and I want to congratulate him from Colombia. Today, previous consultation in Colombia is considered as the focus of a constitutional international debate with different economic perspectives. For some sectors, it became an obstacle, especially for economic development, for the free trade. For other sectors, it has become a restless struggle, trying to pursue these advances, to rethink the law. And we are not exactly close to find a place where these two extremes may dialogue. We are in the pursuit of different place. This with the market economy and with the uncontrolled consumption, it's difficult to understand that in the West. In the Western Hemisphere has a logic of the bourgeois, of the individualism, of the borders, of national borders. And for indigenous people, this is completely different. It's the spirit, is the sense of belonging and to connection with your ancestors, their gods, their pachamamas. So to be surrounded by these visions on one single place, one single element. So it's really difficult, and I want to share. I agree with Professor Marez that it's a shame that our legal framework has become so restricted, so squared, so limited. Some speak of the struggle of different civilizations, or situation of the global South against the global North. But I want to bring you a light in order not to remain in the shadow. I think that we have a different sensitivity in terms of our challenges and in the face of this monster Hydra, where when we cut off one tentacle, 10 new tentacles arise. So indigenous peoples, they are more prepared for that. And I think they are the defenders of their land. This gives them more instruments and ways of generating new processes from a perspective of equality. And we have seen that in a constitutional court in Colombia. We have cases, some cases to be studied, some due to legal decisions, other due to the sadness of the consequences. And I think that this gives, but there are cases that give me hope. So this right to say no is relative. I don't know if this becomes an exception. There are so many elements, especially in Colombian law. And all of the rights are based on this equivocal concept that, so we must understand that in order to say no, you must have an acknowledgement on the part of the state that the people exist. So you must get submitted to a process and a state certificate to be a people. But this is not right. And another key element for the government is that to have a juridically recognized territory is another problem. So what do we do with so many peoples that have been displaced due to violence, to economic actors? What do we do with them? They have a different way of relating to the territory. So this is a challenge. And the other is about the property deed and what is a public property. The states understand that there is an essential property, it belongs to them. But we are the state, we are plurinational state and we must respect each one of our rights of self-determination of our people. So if we don't see this day, our state becomes a small state, only a slave to economic development. And there are other challenges about this new dynamics of the economy, of the market economy. We see this as very difficult to understand, the process of energy transition. What should we do with the air, with the soil? How should we relate to them? How should we protect it? And the earth, how are we going to consult the earth? There are so many problems, so much pain in the earth, in the forests. So when we talk about wind energy, for the solar energy, how should we consult the earth? There are so many challenges to implement the guarantees provided by international law in this in our minor achievements in terms of our internal law. We have a lot of reasons to meet again. I hope to do so very soon. And this is the link for the last book that we have just published. We're going to launch it tomorrow about our process. This is the book Voices of the Amazon, the present and the future of the rights of nature and human rights, to break with this anthropocentric paradigm of understanding not only elements of nature, but going beyond and thinking of complex systems where people, nature are all included. And The law must be disruptive, must be critical. We should, and it's our obligation as academics to think out of the box and to try to find paths that are not going to be simple, but a long time, I'm sure that we will reach what Colombia has already managed to do in its sentence of 2017 about the subjectivity of the rights of people. We are going to start talking about different biomes, different systems, and this has led to a very close dialogue with the rights of originary peoples. They are the last guardians of the forest. So without further ado, Diana and Professor Mares, it was a pleasure to hear from you, also the other speakers, our brothers and sisters. I know that's difficult, but let's not give up. We'll meet again very soon. Thank you. Thank you, Professor Julian. Good afternoon.
Muchas gracias, un gran gusto. E professor Marés,
And Professor Mares,
já ia falar em espanhol com o senhor.
I was going to speak Spanish to you.
Seguindo para o encerramento aqui,
So we are going towards our end. There was only one people that asked for the floor, Alberto.
se ele consegue
I don't know if he manages to
uso do microfone.
speak and use the microphone.
Enviado a mensagem. Sim, por favor.
Escucha. Gracias,
Sim,
Liana.
le escuchamos. Gracias a ti.
Muchas gracias, Liana.
Can you hear, Liana? Thank you. Thank you, all the speakers, our Woye and Bel Huruna, Professor Julian, Professor Frederico, and Roma for this wonderful organization. I'm going to speak about the experience of learning of international law that I had with our brothers and sisters of Roma in the space for the struggle about the binding treaty on businesses and human rights. We have made some advancements about that, about the previous informed free consent in this negotiation that says that now we are introducing the concept in the text, not only about consultation, but consentment of indigenous people. So these peoples should have the right to consent and a free informed consentment. This was an achievement that we were able to make, but there are still challenges in this context. For example, for me, it's not clear that consultations should be made by the state and not by companies. The companies, they are the ones that want to make this consultation. But I want to ask a question, and that's why I'm participating in this section. We know, Professor Federico was saying very directly, Convention 169 of ILO refers to tribal indigenous peoples. This is concretely defined. So there's no doubt that in the binding contract of the UN, it applies to many other communities, not necessarily community indigenous, that also claim the right to say no. To say no to the development imposed by neoliberal capitalism sectors or transnational companies. We understand that and we know that there are organizations that defend this differentiation. They have different characteristics that have been like invaded by capitalism and colonialism before. be respected in this condition. Another different element that must be discussed is who, here in Uruguay, for example, sometimes people claim the right to say no, the right to offer their consentment. These are communities. The concept of community, they can be, a community can be large property owners or farmers that defend a development project. The government is trying to drive not only to one specific sector. So this right of previous consentment should only apply to indigenous people. I know that in Brazil, or if this should be extended to other communities, or if we should differentiate this to different peoples, to the right to previous informed consentment, and consultation is for indigenous and tribal peoples, and we should write for the right to say no. We must. So this is what I wanted to bring and to hear from your opinions, because we must solve this in the context of, in this context, but and in many other contexts as well, in our struggle against the transnationals and their power. Thank you.
Bom, eu acho que eu posso responder em português mesmo, né?
Can I answer in Portuguese? What Alberto is asking is if the right to consultation should be restricted to indigenous and tribal people, or should it be expanded to other communities that are not indigenous and not tribal communities. The concept of tribal and indigenous peoples are very well established in the convention, but before being established in the convention, it's a concept that was created and developed for along the 20th century. In the end of the day, and that's why we were talking about subjective right, it's about the existence of human groups, socially organized, that are different from national society. So the mark of these people and the difference between indigenous and tribal is the moment when they were created or born, if it was before the colonial process or within the colonial processes. The characteristic of these peoples is their organic differentiation, different from the national society. I could call it also hegemonic society, and I could call it colonial society or capitalist society. So these are people that live organically outside the societies. These people, they have these rights. The peoples and communities, the fiction of modern law is that these communities do not exist internally or externally. Now they are recognized, but that internally that they do not exist. Not even a community called family exists as a collective right. So it does not exist on the side of the hegemonic society. Now, what we have is this construction for the societies that are out of this framework. Now, this society that Alberto refers to, a group of, I don't know, farmers or big property owners, or even militia that control the slums, the favelas, for example. They would they have the right to make a stance in face of the state, to contest an action of the state, or a mining project in a territory or in a cattle raising farm, those who are inside the system, what is the characteristic of being part of a system, of being inside a system? Even if a person is unemployed, this individual is part of the capitalist relations, even if they are against capitalism. So my question is no. My answer is no, because the system, the legal system, the Western modern hegemonic system creates different forms of popular participation. So we have a parliament, we have our elections, we have our internal discussions, and the class struggle exists. But environmental movements, can they limit actions of the state that are that go against the environment? They should, but not using Convention 169. The Convention is not the proper instrument. They have other internal instruments in the society that are here. There are internal instruments, but not for those who are outside. So this must be made clear to distinct these different words. This is a difference between different words. I would say, and Julian said that, I think that his book deals with that. Let's read the book that he has just launched, that will be launched tomorrow. There are other beings that are not integrated in capitalism and in nature. Julian's referred to the rivers, to the books, to the sun. Can these beings say no? How will they be consulted? How are we going to consult a panther or a tiger or the forest? If we will consult a boar, maybe before he will eat us. So how do we do that? How we articulate this thing? The only way of articulating that, and we are in a living society, humans are perpetrating this violation. So this only way we have to articulate that is through human societies.
E estabelecimento de princípio, e aí eu quero chegar ao ponto, a sociedade
Establishing principles. The hegemonic capitalist society established as a principle the right to exist of external groups. So these external groups, if they are ensured internally as existing, all the conditions of existence have to be maintained. It's a principle. The state, capitalist state, has already decided about the existence of biodiversity. So the maintenance of biodiversity requires the existence, requires its own existence. So the contradiction of elements that destroy it. So I return to mining. The clearest example, it's destructive of biodiversity. So the authorization that the state gives to mining is an authorization contrary to its own right, because the principle is the life of biodiversity. And the state is, by granting a mining permit, is contributing to a reduction in biodiversity. Most concrete cases, that's how it happens. So the protection of the principles that are established in the general norm of hegemonic society is what governs the action of the hegemonic society. It has to be from the roots, in other words, has to be radical. That's why Choclain was saying, how can you ensure the existence of the Choclain people without the territory if we don't have the right to be in a certain place? They have not been in their own place for a long time. That's why they're resisting and existing. So if the principle is their existence, they must have a place to live. It doesn't matter if they were there in 1988 or not. It doesn't matter. That's the least important part. What we're discussing is their existence. And so that's what we're talking about fundamentally, and not the existence of corporations or of societies. Otherwise, we would say the mining corporations have the right to exist. Otherwise, they will end. So imagine that there's no right for Belo San to produce gold. Oh, but Belo San was created to mine gold. It'll cease to exist. Yes, it'll cease to exist because it's a corporation internal to the system, not external. It is not a people. It is just a corporation. And it's not even made up of people. It's made up of capital. So the convention, the concept of pride of tribal peoples is broad. Yes, a peasant community, traditionally a peasant community, can be considered a tribal community. It may be, but it needs to identify itself as different from the hegemonic society. That's the condition, the self-identification, which is different from the hegemonic society and the other non-hegemonic societies. So if Chavantes call themselves Chavantes, they identify with other Chavantes. Chavante is an indigenous people in Brazil, but it's different from the other Kayapó ethnic groups and other indigenous people, and very different also from the hegemonic society. Okay, thank you, Professor Marés. Thank you, Alberto, all the participants, everybody who raised their questions. I would like to continue this discussion. I think the last point about the right to exist. So, Voya, I'm gonna ask you for your concluding remarks because we have to conclude. We have gone over our time. We have to conclude because we're way past our time. The interpreters have to have to leave. I want to say thank you to Homa for this space, for this debate. Professor Marés has provided some light for our resistance. We want to fight we need to fight to exist. The indigenous peoples vis-a-vis the struggle for land to keep the forest standing. It's not just for our own good, it's for the good of everyone, to protect our air, to protect our water, for all. So that's why we gift to the rest of society. So thank you very much. All the best to you all. Thank you, Voya. So now we're concluding. I want to underscore the fact that all these very deep reflections, I want to say a thank you for that. I'm very proud to have been supervised in my doctorate by Professor Marés. So we arrived at the right to veto. I remember my first meeting, supervision meeting, way back in 2012. I've even lost track. 2012, I think. Professor said to me, "Is your thesis about the right to veto?" Here in Brazil, I think I'm the only jurist that is in favor of this right. So that's why I came to you, Professor. So I pay homage to Professor Marés. So the right to consultation loses its reason to exist if there is not the right to consent and to not consent. Otherwise, it just loses its reason. I reflected about this thing about this in my thesis because the term veto takes us to the idea of national sovereignty, and the state does not accept that. But it also refers to the affirmation of right of determination. So it's not about denial of something. So it's not to say no, but to say no is to say yes to something different, to say yes to existence of these peoples, to say yes to life. And Beljuruna has joined us. Oh, I didn't know you were still in the room. So your concluding remarks, please. And before I hand over to Bel, that is to close the panel, which is very legitimate for you to open and shut it. What Alberto said, just to make sure that you know, yesterday we had a workshop about the protocols of consultation with Claudia Di Pinho from the Pantanal region, Jefferson, who's a Quilombola lawyer who represents these other subjects beyond the indigenous peoples, these other subjects, collective subjects of rights of traditional communities in Brazil, non-indigenous traditional communities. Just before Bel, I did not greet her. Now I see her. So it's a pleasure to meet you, Bel. The struggle continues. We cannot stop. I received a booklet about your protocol. I received it from a researcher who I met in Brasilia. She gave it to me. So that was all. I put on the chat a request for support for the Choclen people. If people can contribute with food or money, anything you can contribute, it's because we are having to rely only on our own selves and on the generosity of people. No public body is supporting us, so we are there on our own accord, fighting for all. Okay, thank you. Hugs all around. Okay, Voya. In Brasilia, we also gave you this booklet of the protocols, and we were at an event with Cunhangue and Tiguaçu, and it was distributed, the Juruna protocol, with the support of the lawyers of ISA who were there with us, who work in Altamira, and distributed it in the workshop we had in Brasilia, which had the participation of Choclen women leaders. So I plug the book because for the Spanish-speaking comrades, brothers and sisters, has the participation of Professor Carlos Mares, translated into Spanish. And I put it in the chat, the link to the observatory where you can download the book for free, okay? Bel, please. I was here the whole time listening. I just want to say thank you for the invitation to take part, all the participants, my Choclen relative. We feel that any mobilization, demonstration, it's about defending our territories, defending our forests, our rivers. It's for the greater good. It's not just for us. We are all beneficiaries of our forests, of our rivers. So what would happen with the world without the indigenous peoples looking after the earth? We are people. We have the understanding and we're able to talk for our land, to speak for our rivers, for our forests. Our rivers can't talk, we can talk for them. We live in the forest, we live in the rivers or on the riverbanks, so we understand them. We understand that they're being threatened, and we all suffer together. So everything is connected, and we are fighting for the greater good. And we want to grab what we can. Today we have Convention 169 and the consultation protocols are a good method that is being adopted in Brazil. Many people are having this understanding that they need to have the protocols because it's a roadmap, it's a guideline, it's about this law that Brazil is a signatory of this convention. So in a moment such as this, that's why I'm so grateful for the invitation to talk about the protocols of the Juruna people, the actions, the support, the success we've already had in some questions regarding the Canadian mining company. So I just want to say thank you to be able to share all of this. These are moments that strengthen us, that disseminate our struggles, knowledge of our struggles, our successes, our victories. And so they reach, I don't know, other countries and other spaces. So that is part of our strengthening, of our empowerment. So this is the protocol consultation of my people. Here, I just want to say thank you. It's no use having a protocol, talking to our people to make them understand that we need this. It's no use if we're not able to disseminate it, to publicize it, to make sure that it is known. We can't just put this book on the shelf and then when we have a crisis, we take it off the shelf. No, we need to constantly strengthen our organization. And another positive thing was because, thank God, ISA and RCA helped us. The moment that we needed, we had support from these organizations. That was the final push. We were already organized, but it was the final push to get this document concluded, printed, produced, etc. So thank you, special thank you for the invitation. Thank you, Liana. Thank you, my relative. We're in struggle. Our struggle is big. We have always had to struggle. We have never given up and will not give up. So while there are indigenous peoples in Brazil, we're not going to stop the fight for our territories, for preserving our territories, because we all depend on it, all human beings. So that's it from me. Thank you, Liana. Bye-bye. Thank you, Bel. So that, with that, I think we can conclude. We had a very successful panel. I thank the organizers, the team, particularly Manuela Roland, coordinator of Roma, and all the team, Roman, Felipe, Fernando, with the broadcast, the organizers, and special thank you to Raquel Hernandez from the rapporteur of the United Nations office, who sent us a message of support to the event and of solidarity for the struggle of the indigenous peoples in Brazil. So in support of this panel in particular. So thank you all, big hugs, more to come tomorrow. Today, the evening workshop we have as facilitator Jenna and Paula about people's legal advisory services. Thank you all for your participation, particularly our panel members. Bye-bye.